Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a big show for you today since I've been in trial all week. First, the judge in the Gutierez-Reed case seals the jurors' names over perceived threats. Hannah Reed Gutierrez says, hey, what about me? Is her case going to get dismissed? The Black Swan murder trial begins Monday, and we'll bring it to you live. Has there been another leak in the Delphi case? The documents case gets dismissed against former President Trump. Road rage. How many times have I said, just let it go? Let me give you another example. Don't live stream the crime scene. We've talked about that before. Another example of how not to act on an airplane. And then finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. It is Friday, July 19th, 2024. It's the first show that we've done for the week because I was in trial. And I must say, we were victorious. Yes, client completely vindicated. It was a little bit of a different kind of a twist. It wasn't a criminal case, but it was a civil case brought to enjoin my client from engaging in any alleged future conduct out of fear that it would potentially cause voter intimidation. We'll talk about it more in the next coming weeks. There's still a couple of things that need to be resolved, so probably best that we just not talk about it. But I think it's an interesting issue as to how it all went down. I think it's a very interesting case, and I think it'll be interesting to talk about in the future, but maybe now is just a little premature. Anyway, that's where I was all week, but glad to be back. Thanks for joining us. So let's go ahead and open the record. And first on the docket, the Gutierez-Reed case. That's right. The judge, citing jurors' credible and reasonable fear of their safety and their family safety, has ordered the indefinite sealing of the Gutierrez-Reed murder trial juror list. Now, on July 1st, the judge declared a mistrial after the jury of 6 women and 6 men said they were deadlocked in their deliberation on the charges that Miss Reed had killed her boyfriend, former police officer John O'Keefe. Now, through affidavits, juror Doe has established that publication of the list identifying the names of the impaneled jurors will present a real and present risk of personal harm to jurors and to the integrity of their service, the judge wrote in her order. The jurors, if identified, are likely to become targets of harassment, abuse, doxing, and potential violence. Juror John Doe noted in their affidavit describing the nearly unprecedented and vitriolic public interest associated with this case. Now, the juror, identified as Juror Doe, wrote that they recalled testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in this case. The affidavit continues, I do not know of any specifics of any such harassment, but I fear that my family and I will not only be harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. The order does not preclude any juror from identifying himself or herself and from speaking in public about the case. So this is interesting. Now, in the motion, there were several attachments of anecdotal stories about people harassing potential jurors, or what they believe to be harassment of potential jurors. Well, coincidentally, I just happened to have a case like this that I was in trial with all week. Now I just happen to be in a trial all week, kind of a very similar situation. Do you grant something out of fear, and whether it's reasonable or unreasonable fear, or do you have to wait until something allegedly happens? Well, I don't know. I understand the judge has the authority, says, hey, you know what? It's just safer to keep the juror list silent. That's fine. But in the motion, there are many details where they believe that the Gutierrez-Reed supporters are a little over the top when it comes to this case. Now, I've noticed when we put up a video allegedly showing the attorney and Miss Reed in a slight embrace. I know. Why are you bringing that up again, Scott? Well, the point is, people from the Gutierrez-Reed camp have said it's not fake, and neither the attorney nor Miss Reed have come out to say that was fake. So do with what you want, okay? There are people that are going to believe something. There are people that are going to deny something, okay? There are actually people out there that think the former president, Donald Trump, didn't get shot last Saturday in Pennsylvania. They believe that it was all staged. It was fake. Okay. The last guy who said that a shooting was staged or faked, guess what? He got sued for $1 billion. That's right. You would think that people would learn. When you get sued for $1 billion by saying it's a false flag type of thing, you probably shouldn't do it. And unless you have definitive information that says it's fake and the people that are supposedly in the photographs are not denying it, remember, the attorney cannot come out and say, oh, that's a complete fake. And yet all those articles are still up. I checked just last night. So I've seen the Karen Reed folks. They are quite supportive of her. I say good for her. Hey, the jury, as far as we know, did reach not guilty decisions on 2 counts, but they also believe that she was guilty on the 1 count, the vehicular assault case. So, I mean, the juror looked at it and said, we don't think she intentionally killed the guy, but probably did it while she was drunk. So she's not, I mean, it's not a win, so to speak. The judge isn't going to throw the entire case out. The prosecution is going to say, fine, even if we dismiss those 2 counts, but we'll try again with a new jury. Guess what? They were ready, almost close to convict her on the final count. So it's kind of like the road rage thing we're talking about, ladies and gentlemen. Like, most of you people get involved in a lot of these cases. It's not like it's a personal friend of yours. It's not like it's a family member. It's a case that you find very intriguing and interesting. And let the facts roll where they may. You can take a side. I think this supports this. These facts supports this argument. This fact weakens this argument, and vice versa. But it's court. We don't need to go around harassing jurors. And I'm not saying any Karen Reed people are harassing jurors. I'm just saying everybody needs to take a chill pill. Nobody likes when there's a mistrial. Nobody. That means everybody has to do it all over again at great time and expense. But leave the jurors alone. Bottom line, they were there doing their civic obligation. They did not ask to be on that case. They basically donated their time to appear. Give them the respect that they deserve. And they shouldn't have to reveal or speak to anyone, nor should they ever have to be in fear of harm or intimidation or doxing from anybody because somebody doesn't like the way they think they may have deliberated in a jury room. That's just offensive if anybody does that. And if anybody thinks that that's not offensive, let me know. I guess you can unsubscribe, right? Everybody always tells me when they're going to unsubscribe. Okay, I get it. Anyway, that's all I got to say about that. Next, Hannah Gutierrez says, hey, what about me? That's right. The movie Armorer has asked the judge to dismiss her involuntary manslaughter convictions or convene a new trial in the shooting deaths of cinematographer by actor Alec Baldwin, alleging suppression of evidence and misconduct by the prosecution. Now, Miss Hannah Gutierrez-Reed was convicted back in a jury trial in March, overseen by the same judge who later gave her the maximum penalty. And it was the same judge that oversaw the Alec Baldwin matter. Now, Gutierrez-Reed has already appealed to a higher court on the involuntary manslaughter conviction. So it may take a little time, and the court may say, oh, I don't have jurisdiction, but they'd probably have to ask for a limited remand. Anyway, defense counsel for Ms. Gutierrez-Reed has argued that the case should be reconsidered because the prosecution failed to share evidence that might have been exculpatory. Now, the prosecutors blamed Gutierrez-Reed for unwittingly bringing live ammunition onto the set of Rust, where it was expressly prohibited, and for basically not following basic gun safety protocols. Well, the judge last week brought Baldwin's trial to a quick end on misconduct allegations of the police and the prosecutors over the withholding of the evidence from the defense in the 2021 shooting. Now, the court stated on July 12th that the integrity of the judicial system demanded that the court dismiss Mr. Baldwin's case with prejudice. And the attorneys saying, how can this be any different for Ms. Gutierrez-Reed's case with this proven litany of serious discovery abuse? Now, Carrie Morrissey, the lead prosecutor in both the Baldwin and the Gutierrez-Reed cases, said her written response would be filed in court next week, isn't commenting further at this time. Now, the case-ending evidence at Baldwin's trial was ammunition that was brought into the sheriff's office in March by a man who said it could be related to Hutchinson's case. Prosecutors said they deemed the ammo unrelated and unimportant, while Baldwin's lawyers alleged that the prosecutors deliberately and intentionally buried it and filed a motion to dismiss the case. The judge agreed. The prosecutorial misconduct, accompanied with the police misconduct, warranted such a drastic remedy. Now, the motion that was filed on behalf of Gutierrez-Reed also accuses Ms. Morrissey, the prosecutor, of lying about why fellow prosecutor Erlinda Johnson quit in the middle of the hearing and the circumstances of how her former paralegal came to leave her office. Now, Gutierrez-Reed's attorneys filed a 35-page motion where Gutierrez-Reed accused Morrissey of repeatedly lying to the court about the ammunition. And specifically, Corporal Alexander Hancock testified that Ms. Morrissey was in the decision to file the Teskey rounds in a separate file. The motion reads, referring to lead detectives in the case. On direct examination, however, Ms. Morrissey stated that she never knew it would have a separate file number. So what to do, ladies and gentlemen? Clearly, the prosecutor appears to possibly be ethically challenged, as were the police involved in that case as it related to the hiding of evidence, as it related to the ammunition that could have been relevant in the Gutierrez-Reed matter, as well it was obviously in the Alec Baldwin matter. In reality, at the end of the day, it may have been of little significance whatsoever to the jury. But the fact that the prosecutors and the police got caught red-handed, hiding evidence and then basically lying about it, not good. Ms. Gutierrez-Reed has gone through this process, and hopefully she will learn through this process. I believe that Ms. Gutierrez-Reed should have her convictions vacated, and her case should as well be dismissed with prejudice. I think before the judge could do that, she would have to call on the prosecutors and the police to have a hearing as it related to that particular evidence. Unless she were to adopt it from the Alec Baldwin trial, since she was the trier of fact, and make the same findings of facts and conclusions of law that the police hid intentionally that evidence by filing it under its own case number so that it basically would not be found by the defense. Ethically challenged prosecutors, ladies and gentlemen, ethically challenged police officers. And you have to admit, cross-examination, the greatest truth-seeking tool ever created. When somebody is forced to sit there on the stand, to have to answer relevant questions, it's suddenly the truth, or a pretty darn close version of it, comes out. And I will tell you, probably next week or so, about what happened in my trial, where there is also people submitted documents and it came out on cross-examination that weren't exactly true. It happens, ladies and gentlemen, and the only way it was going to be found out was through cross-examination. So give Miss Hannah Gutierrez-Reed her freedom back, vacate her conviction, dismiss the case, and I hope that judge would then submit a bar complaint herself against the prosecutors, and there should be some sanction for the police as well. But let's face it, it probably won't, because they all protect each other all the time. Next on the docket, the Black Swan murder case. That's right, that case begins on Monday, and this is the case that gained some national attention after it was featured on 48 Hours. Now, the case has been called the Black Swan murder trial because it involves a woman by the name of Ashley Benefield, a former ballerina accused of shooting and killing her estranged husband. Now, Benefield was in court for pretrial hearings and is still hoping that the Florida Stand Your Ground law will help her claim of self-defense at trial. Now, Ms. Benefield is charged with second-degree murder, which dates back to September of 2020 regarding the death of her husband, Douglas Benefield. Now, the shooting is alleged to have occurred in her mother's home in Central Park area near the Manatee County down in Florida. Now, outside of Manatee County courthouse, a large group has gathered in solidarity of Miss Benefield, and apparently they've been marching for days ahead of the trial to drum up support, chanting, "We stand with Ashley. We stand with Ashley. Anyway, investigators said that the former ballerina and bikini model shot and killed her 54-year-old estranged husband in the White Rock Terrace area in Lakewood Ranch. Now, records show that Benefield claimed that her husband of 4 years, whom she met as a widower and married after a 13-day whirlwind romance, was abusive and had charged at her. Her mother says she's being punished for surviving. The mom says, how horrible to want to destroy a mother and a daughter who did not do what they said they did. How horrible, her mother states. Now, investigators allege that the couple had been separated and were tussling over custody of their daughter, now 6 years old. Their daughter was joined in hitting the pavement in support of her mother, stating, quote, I kiss her sometimes and I hug her. I feel like I am standing up for the right thing and I'm going to stand right here, Ashley's daughter notes. Now, in court, the judge addressed several issues, including the state's request for the defendant to proffer a domestic violence expert or battered spouse syndrome, which was denied. Now, last year, the judge also denied the motion to dismiss on the basis of immunity from prosecution provided under Florida's Stand Your Ground law. Now, if convicted, yes, she could be sentenced up to life in prison. Trial begins Monday. We intend to bring it to you gavel to gavel coverage. Stand your ground, always interesting, ladies and gentlemen. Yes, usually if somebody's in your residence, they come at you. You do not have to retreat. You can shoot them, castle doctrine, all that type of stuff. The court can make a preliminary determination, say immunity, case closed. If the court denies it and says, this is really a question of fact, it's a close call, the jury gets to decide it. You still get to raise that defense, and basically the jury decides whether the killing was unlawful, was not unlawful, because it was justified under the law. We'll have to wait and see. Next, the Delphi case. That's right, another leak you think somebody would have learned. For those who don't know, Richard Allen of Delphi, Indiana, was arrested back on October 28th of 2022 for the February 2017 murders of 13-year-old Abigail Abby Williams and 14-year-old Liberty Libby German near the Monon High Bridge in Delphi, Indiana. We've talked about this case quite a bit because there's been a lot of drama with it. I'm not going to go into all that again. You would think the defense and people associated with the defense would be a little more cautious, courteous, not reveal attorney-client confidences, those types of things, so that the judge can refer to you as an idiot and basically state that you are a walking case of malpractice. Well, it may have happened again. So there's been some leaked conversations between attorneys close to, I'm not saying it's the attorneys, close to the Delphi murder case, and a YouTube true crime podcaster, and it appears to reveal the defense team's strategy going into the suspect's October trial. Now, quote, we were quite surprised to see that people closely affiliated with the defense team were in such extensive contact with internet sleuths because previously this case was derailed by a leak. The group chat was called Due Process Gang. It consisted of Kara Weinecke, a lawyer who represented Allen in the fight to keep the attorneys on the case, an attorney representing Allen's attorney, and several YouTubers who talk about true crime cases, including the Delphi murders. Now, one of the podcasters said our sources did this because he became very concerned about the level of contact between the internet folks and the people affiliated with the defense team. Now, the attorney, Weinecke, stated that the group chat was filled with people who love true crime as she does. She talked about cases happening across the country. She claims the screenshots were obtained illegally, and Weinecke shared she stated in a statement. Now, recently, out of revenge, a person who knew the password of one of my accounts accessed her ex account and copied all of her private conversations. He gave those conversations to Murder Sheet, who read some of them aloud and on a recent episode. The conversations were blended and the messages were read out of order and context. Their purpose? To make it seem like we were hired by Allen's defense team to sway public opinion. We were not. Kane and Greeley said some of the messages in the group chat bring up ethical concerns of potential jury tampering, particularly when Weineke is alleged to have said that others talk about giving YouTube internet sleuths surveys filled out by potential jurors so they can do background investigations on them. Now, the podcaster said this becomes uncomfortable when you're bringing internet sleuths who are not even from Indiana and have zero training. Even if they're signing non-disclosure agreements, that should pause people, because in the Delphi case especially, internet sleuths do not have the best reputations as far as ethics, or not going as far as harassing people. Now, Weineke said, I expressed doubt that the defense would have time to vet hundreds of jurors before the May trial date. A friend offered her help. I said I would let the defense team know. I did. They said no. That's not jury tampering. Anyway, the Murder Sheet podcast stated that the group chat also revealed the strategy of the defense team by talking specifically about how they plan to discredit the ballistics experts who matched the bullets found at the scene of Allen's gun. Now, Weineke, the attorney, once again pushed back and said, I didn't reveal that strategy. The defense revealed that strategy on page 2 of their press release before the gag order. They revealed it again in their ballistics motions. They revealed it repeatedly in their court filings. We'll have to wait and see. Allen is scheduled to be back in court on July 30th for 3 days of motions hearings. Unfortunately, that's right, the judge probably is not going to televise it. Now, this raises several issues, ladies and gentlemen. You can't, if you're associated with a case, you can't talk about it with really anybody. You can't. You have to talk in very vague generalities, so to speak. And you can't reveal attorney-client information. And if you are the attorneys of the attorneys that represent the alleged Delphi murderer, you probably shouldn't be discussing that case with anyone, just out of your better judgment. And you better be absolutely certain that it is of public information. Now, I don't know exactly all the specifics. We'll have to wait and see if it's going to be an issue on July 30th. However, it sounds like the attorneys for Mr. Allen did nothing wrong, but they all may want to do a quick refresher course on their confidentiality issues that keep arising, and maybe refresh their ethics, that they can't reveal attorney-client confidences to anyone. Next, the classified documents case against former President Trump has been dismissed. Now, federal judge Eileen Cannon has dismissed the classified documents case against former President Trump, and Mr. Trump was accused of taking highly sensitive national security documents to his Mar-a-Lago estate when he left the White House. FBI agents seized a large amount of material during the search of his Florida home back in August of 2022. Judge Cannon threw the case out based upon violations of the Constitution's Appointment Clause and Appropriations Clauses. Yes, ladies and gentlemen, when I say the Constitution matters, it's the Constitution here that matters. You can't just go around appointing people to be prosecutors. And that's what the judge found. It said in her ruling, Judge Cannon found that the appointment of special counsel Jack Smith was unconstitutional. Now, it had significant impact on President Trump's legal battles, as he now has just 2 criminal trials, the one in Georgia, which probably will get reversed on prosecutorial misconduct and certainly won't go before the election. And then we have the federal trial related to the January 6th incident, which the United States Supreme Court ruled upon, and there has to be a hearing held as to what was official acts and unofficial acts, because the court determined what everybody already knew, was that if you were the president of the United States, you had immunity for the acts that you did. Otherwise, nobody would ever take the job if they thought that they were going to get prosecuted by their opponents every time they left office. It was so obvious that no one ever had to deal with the issue until now. The president was charged with these various cases. Anyway, the Justice Department may try to appeal the decision because they've had some success in having Judge Cannon's decisions reversed previously. Now, they also have the option, as you may recall, this was kind of a weird thing. The documents case was presented to a grand jury in Washington, D.C., and then they transferred the indictment to Florida. So one of the issues is that since the special counsel who presented to the grand jury was appointed unlawfully, according to the judge, I don't think they could use those same proceedings. So then the question would become, would the Southern District United States Attorney prosecute the case? I think they would have to start all over. Now, the prospects of that, I think, are quite weak, given it is in Florida, even if it is a federal prosecutor. Anyway, the court noted if there is no law establishing the office of the special counsel that they occupy, then he cannot proceed with his prosecution because a private citizen cannot criminally prosecute anyone, let alone a former president, the judge wrote. Now, the judge noted and took some cues from Justice Clarence Thomas from the United States Supreme Court in his immunity case, and she states, if there is no law establishing the office of the special counsel in which they occupy, then he cannot proceed with the prosecution. A private citizen cannot criminally prosecute anyone, let alone the former president. That was the quote that Justice Thomas wrote in the Supreme Court decision as it relates to immunity. Judge Cannon adopted that. So in her 93-page ruling, Cannon ruled that the appointment of officers, such as special counsel, resides exclusively in the rules and power of Congress, not the executive branch. So Attorney Merrick Garland designated the special counsel in a move intended to provide isolation from charges of political interference had his office prosecuted the case directly. But the judge was unpersuaded that authority existed. Although special counsels have been used in a variety of high-profile probes over the years, the framers gave Congress a pivotal role in the appointment of principal and inferior officers. That role cannot be usurped by the executive branch or diffused elsewhere, whether in this case or another case, whether in terms of heightened national need or not. Boy, the appointments clause, officers, inferior officers, where does that sound case? Oh, that's right. That was also the case of former President Trump trying to be kept off the ballot in the state of Colorado. Once again, Supreme Court batted that down and said the Constitution matters. Anyway, in this case, the court notes, the inferior officers, that means that Congress is empowered to decide if it wishes to vest appointment power in the head of a department. And indeed, Congress has proven itself quite capable of doing so in many other statutory contexts, she writes. Judge Cannon was not persuaded by the DOJ's invoking past special counsels, such as Robert Mueller, who headed the Russia probe, or David Weiss, who handled the Hunter Biden probe, and who was able to remain despite filing by Hunter Biden's counsel. The court noted the distinguishing factor is, in this particular case, was Mr. Mueller and Mr. Weiss had been confirmed by the Senate. It matters. Anyway, in the end, it seems the executive's growing comfort in appointing regulatory special counsel in the more recent area has followed an ad hoc pattern with little judicial scrutiny. Anyway, case was dismissed. So what does that mean? Basically, the government's thing is, well, Judge, no one's ever challenged this before. We've done it before. Why are you going to be the one to throw everything up into a big mess and throw out the case? Because you can't do it. And just saying, well, we've done it before, so therefore we should be able to do it again, is not the law. Maybe no one ever challenged it before. Funny how that works. Next on the docket, road rage. How many times have I said, let it go? I have represented people in so many cases of road rage over the year, ladies and gentlemen. It's crazy, okay? Whether you're driving and you think it's a good idea to show the person your frustration, where people perhaps pull the gun out and put it on their dash or hold it to somebody and wave as you drive by. No, you're menacing, okay? You can't do that. Anyway, we'll take a look at this guy. This video shows an armed man being shot dead in Indianapolis as he's yelling at a driver in this alleged suspected road rage. Now, this footage was originally shared on social media, and it shows Gavin DeSauer quickly approach a white Chevy pickup truck on Tuesday evening and attempts to punch the driver while holding what appears to be a handgun in his hand. The driver tries to smack the punch away, with DeSauer shifting the weapon to his left hand and appears to berate the driver further by repeatedly pointing with his right hand. Well, guess what? The driver of that car points their own gun at DeSauer, firing one time, and DeSauer drops like a sack of potatoes. Dead. Now, the 7-second video capturing the chaos ends with the person filming the exchange taking cover in the car. The guy that was witnessing it told police that the shooting occurred over an alleged road rage incident involving a black Honda and the Chevy driver. Now, the driver of the pickup truck was initially detained but was released after investigators found that the driver was acting in self-defense. Yes, ladies and gentlemen, if you approach someone with a gun and the other person has a gun, they're probably going to shoot you. They're probably justified, particularly if you pointed it at them first. It's called self-defense, right? In most states, you have a right to defend yourself if you reasonably believe, that you are in fear of death or serious bodily injury. A man running up to your car with a gun, berating you, one could say that you are in reasonable fear of serious bodily injury, i.e. being shot, or even being killed. As you can see, it only took one bullet. So let it go, ladies and gentlemen. Next time that guy cuts you off, next time somebody's driving too slow and you can't get past them, let it go. I'm telling you, it's not worth it. Take that advice for whatever it's worth. I know it's free legal advice, probably worth the what you paid for it, but the reality of it is free. And you want to remain free and at liberty, so don't do it. Next, don't live stream the crime scene. So a robbery suspect is under arrest after he live streamed himself leading authorities on a high-speed police chase with a baby in the back seat of a suspected stolen car. Now, according to the police reports, the suspect, a 21-year-old by the name of Dayon Henderson, was one of two who allegedly robbed a man as he sat in his car in Beverly Hills. Now, the victim was allegedly sitting in his car in the area of Cannon Drive and Charlesville Avenue when he was confronted by Mr. Henderson and another suspect who drew guns on him. And guess what? They forcibly took his property, which included a Rolex, his watch, a ring, and a phone. That's aggravated robbery, ladies and gentlemen. Well, in the Instagram live stream, the baby's mother can be heard in the background yelling, "Just pull over and put your hands up. My baby is in the car. Dayon, bro, Dayon, just pull over. Let us out." Anyway, the chase ended in Culver City, where Mr. Henderson briefly stayed in the car as the deputies boxed him in. After a few minutes, Mr. Henderson came to his senses, surrendered, and exited the vehicle. The mother also got out of the car carrying the baby, and Henderson was seen kissing both of them. Now, according to the arrest records, Mr. Henderson is being held without bail, and he was booked on felony evading and 7 felony warrants. The other 2 suspects arrested were a 24-year-old Sema Lopez and 19-year-old Michael Smith. Both were booked for the robbery. The baby's mother was not arrested. It was determined that she was, in fact, a victim of a kidnapping. If it's worth having, it's worth working for. Go work for it. Get what you need to do. You don't take other people's stuff. Next, how not to behave on an airplane. It can turn out quite poorly. Please meet Evan Smith. Now, he made 2 separate allegations that his then-girlfriend had a bomb on board, then dumped his drink on his girlfriend and called her the biatch word. When Mr. Sims was questioned by FBI agents interviewing him over his bomb threat, his only question to them was, "How effed am I?" Well, Mr. Sims, let me tell you, since you're a resident of Rhode Island, Mr. Sims was a resident of Rhode Island, but he was sentenced in Florida to 2 years in prison, and he was given the credit for the 8 months that he's already served in jail. Now, as part of his sentence, he also has to pay a fine of about $25,000, as well as restitution to the airlines. That's right, for the cost of the gas to turn back around. Anyway, it is alleged that Mr. Sims, according to the special agent that wrote the arrest affidavit, was traveling on December 5th, 2023, when his romantic partner at the time had an argument. Well, he became aggressive with staff on the plane and was quite obnoxious, not only to his girlfriend, but to the staff, and as well as throwing a couple of fellow passengers, prompting several people to request a seat change far away from Mr. Sims. At one point, the court records indicate that after the flight had already taken off and the seatbelt light was on, Mr. Sims partially stood up in his seat and exclaimed that he wanted to get off the plane. Well, there was an off-duty police officer on the plane, and he overheard Sims making quite the fuss. Anyway, affidavits for the arrest show that when the pilot learned of the disturbance, he made the call to divert back to Jacksonville International Airport there in Florida, and needless to say, it didn't quite go well for Mr. Sims. Now, a flight attendant stated that it appeared that Mr. Sims appeared to be satisfied with the diversion announcement and was smirking while other passengers appeared quite upset by the turnaround. When the plane ultimately landed, Mr. Sims and the unidentified romantic partner were detained and a bomb detection dogs were used to sweep the plane. Smith told the FBI he was only joking around, just joshing, about the airplane going down, and that he was frankly quite nervous of flying. His girlfriend had just broken up with him, and he didn't want to fly to Rhode Island anymore. I guess that's one way of making that happen. Anyway, he says that he didn't say bomb. Either he claimed, because he generally does not use that word, and has a very dark sense of humor. Anyway, 2 years in prison, Mr. Sims. And frankly, I would say maybe Congress could pass a law and say, if you cause a disturbance on the airplane, maybe there's some mandatory prison. There you go. If that's what it's going to take to get people to behave like civilized human beings on an airplane, I think I am for that. Not a big fan of mandatory minimums, but the stuff that's taking place on airplanes, it's just ridiculous. I think is what do they say? A lot of people acting a little ghetto on the plane, all right? Act like a civilized human being, not like you're running the street somewhere. And the other thing, ladies and gentlemen, most of the flights domestically are less than a couple hours. You don't have to pack like you're going to climb Mount Everest. Come on, people. I don't know. Am I fired up today? I don't know. I'm fired up. I won. I should be absolutely happy, but I see this stupidity going on in the world, and I just don't get it. Well, let me give you an example in our dumb criminal of the day of another thing you shouldn't do. So a Florida woman is behind bars after she was spotted vigorously pleasuring herself in public. Now, police officers were dispatched to a local park referencing what they believe to be a male that appeared to be passed out with his pants down. Upon arrival to the Bayview Park, police officers realized that the suspect lying on the ground behind the statue of Jose Marti, the Cuban independence leader, was actually a woman. A member of the public flagged the police officers down and reported that they had witnessed the woman with her pants down stimulating her genitalia. A similar sighting was reported by Officer Frank Betts, who told a fellow police officer that he watched the suspect vigorously stimulating herself. The report does not indicate how long the officers observed the crime being committed, but apparently it was long enough. Anyway, police identified the woman as Teresa Dunleavy of Oklahoma, but her address is listed as the streets of Key West. So I'm going to take it that the streets of Key West is that she is homeless. Well, guess what? She has been charged. Miss Dolvaney has been charged with indecent exposure. Good for her. It's a misdemeanor. She's booked in the county jail and being held on a $5,000 bond. Since she is homeless, I somehow don't believe that she is going to make that bond by her next court date, which is July 26. Now, Miss Dunleavy, obviously I wish you well. I hope you can get back into a situation where you do not have to be homeless. But I can think of worse places to be homeless, the Florida Keys. But the reality of it is, if you're going to do that pleasuring, you need to do it in private, not where other people can see it. That's where it gets a little crazy. And just a little anecdote. There was a man in our neighborhood that was accused of doing such a thing at the swimming pool where young girls were. And I'm telling you, the guy got arrested. And you have a bunch of moms that think that someone's been doing this to their kid. Look out. They are coming for blood for this particular gentleman, particularly the ones that their kids knew the guy. Be careful, ladies and gentlemen. Crazy world out there. All right, that's all we have for you today. Thanks for joining us. I know I was in trial. Next week, we'll have a full docket. Thanks for watching. We'll see you next time. And remember, yes, the Constitution does matter. The Constitution matters when it comes to these type of legal issues, ladies and gentlemen. You can't ignore it. And if you don't like it, well, there's a remedy. Go change it. Thanks for watching. We'll see you next time.